I am now prepared to rule on the point of order raised February 8, 2024 by the Parliamentary Secretary to the Government House Leader concerning the admissibility of amendments made to Bill C-318, an act to amend the Employment Insurance Act and the Canada Labour Code, adoptive and intended parents, by the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities. In his intervention, the Parliamentary Secretary stated that the 4 amendments adopted by the committee during its clause-by-clause consideration of the bill not only exceeded the scope of the bill as adopted by the House at second reading, but also required a royal recommendation, since they seek to authorize new and distinct spending not authorized by the Employment Insurance Act or any other statute or appropriation. In response, the member for Winnipeg Centre noted that since the adoption of the previous session of Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples, all federal legislation must be compatible with the United Nations Declaration on the Rights of Indigenous Peoples, a goal her amendments sought to achieve. She also indicated that the government had the power to provide the royal recommendation required for these amendments.
The House will recall that on May 4th, 2023, the Chair ruled that Bill C-318 required a royal recommendation when it stated at page 14,043 of debates, and I quote, Clause 5 adds new Section 22.1 to the Employment Insurance Act to create a new type of special benefit, namely, a 15-week attachment benefit for adoptive parents and parents of children conceived through surrogacy. The bill also provides for the duration of this new benefit to be extended for various reasons. Implementing Bill C-318 would create a new type of benefit and therefore lead to increasing public expenditures for purposes not currently authorized by the Act. As a result, a new royal recommendation is required for the bill to receive a final vote in the House at third reading, unquote. During the clause-by-clause study of the bill by the committee, 4 amendments moved by the member for Winnipeg Centre were adopted. The amendments to Clause 1 and Clause 8 apply to the Employment Insurance Act, and the amendments to Clause 14 and Clause 17 apply to the Canada Labour Code.
Amendments to Clauses 1 and 8 modify the bill to include, for the purposes of the new benefit created by the bill, a situation where one or more Indigenous children could be placed with a claimant other than the child's parents, in accordance with the customs or traditions of the Indigenous group, community, or people to which they belong. With provisions, the claimant could be entitled to obtain a 15-week benefit drawn from the Treasury, a notion which is not currently provided for in the bill as adopted at second reading. Both amendments had been ruled inadmissible by the chair of the committee since they create a new and distinct charge on the public treasury, and as such, require a royal recommendation. As indicated in House of Commons Procedure and Practice, 3rd edition, at page 772, and I quote, Since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury, or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. End of quote.
Bill C-318 also proposes amendments to the Canada Labour Code to extend parental leave in the case of the transfer of a child through adoption or a child born through surrogacy. The amendments to Clauses 14 and 17 create a new corresponding extended leave of absence to match the benefit established by the first 2 amendments to Clauses 1 and 8. Here, the committee chair deemed both amendments to be beyond the scope of the bill and thus also ruled them inadmissible. In the case of all 4 amendments, the committee chair's rulings were challenged and overturned, and the amendments ultimately adopted.
Knows, the Speaker does not normally intervene on matters upon which committees are competent to take decisions. However, the admissibility of any amendments adopted by a committee may be challenged on procedural grounds in the House after a bill is reported back. As indicated in House of Commons Procedure and Practice, 3rd edition, at page 779, and I quote, "The admissibility of the amendments is then determined by the Speaker of the House, whether in response to a point of order or on the Speaker's own initiative. Lorsqu'elle doit trancher..."
When called upon to deal with such matters, the chair is guided by Speaker Fraser's explanation of April 28, 1992, at page 9801 of the debates, and I quote, "When a bill is referred to a standing or legislative committee of the House, that committee is only empowered to adopt, amend, or negative the clauses found in that piece of legislation, and to report the bill to the House with or without amendments. The committee is restricted in its examination in a number of ways. It cannot infringe on the financial initiative of the Crown. It cannot go beyond the scope of the bill as passed at second reading. And it cannot reach back to the parent act to make further amendments not contemplated in the bill, no matter how tempting that might be," unquote.
In light of the arguments presented by both the Parliamentary Secretary to the Government House Leader and the member for Winnipeg Centre, the Chair has examined the 4 amendments at issue. The amendments to Clause 1 and Clause 8 do indeed propose a charge upon the public revenue and therefore infringe upon the financial initiative of the Crown. While the Chair recognizes that challenges may arise when a committee must examine a bill where the Speaker has previously determined that a royal recommendation will be required before putting the question at third reading, a committee must still carry out its mandate without exceeding its powers. As explained by Speaker Milliken in his ruling from November 19, 2009, at page 6936 of the debates, and I quote, "In my view, by adopting an amendment that infringes on the financial initiative of the Crown, even when it is directed at a clause itself needing a royal recommendation, a committee ventures beyond its mandate," unquote.
As previously stated, the bill aims to create a new benefit and corresponding extended leave for adoptive parents and parents of children conceived through surrogacy. The amendments to clauses 8 and 14 provide that one or more Indigenous children could be placed, in accordance with the customs or traditions of the Indigenous group, community, or people to which they belong, with a person other than the child's parents. This person could be entitled to an extended leave, which introduces a new concept not found in the bill as adopted at second reading. Thus, these amendments do go beyond the scope of Bill C-318.
Consequently, I must order that all 4 amendments adopted by the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities be declared null and void and no longer form part of the bill as reported to the House. In addition, I am ordering that the reprint of Bill C-318, as ordered by the committee, be cancelled. The text of the bill as adopted at second reading will stand as the official version of the bill for consideration at report stage. Given that the bill is now reported back from committee without amendment, the requirement for a royal recommendation, as explained in the Chair's ruling from May 4, 2023, stands. Consequently, I will decline to put the question on third reading unless a royal recommendation is received. I thank all members for their attention. It being 11:15, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Orders of the day, private members' business, consideration at report stage of Bill S-205, an act to amend the criminal code and to make consequential amendments to another act, interim release and domestic violence recognizance orders, standing in the name of Ms. Dancho.
There are 12 motions and amendments standing on the notice paper for the report stage of Bill S-205. Motions number 1 to 12 will be grouped for debate and voted upon according to the voting pattern available at the table.
I will now submit motions 1 to 12 to the House.
Ms. Ferreri. Excusez-moi. Motion numéro 1.
Motion number 1.
Seconded by Ms. Gray, moves that Bill C-S-205 in Clause 1 be amended. A, by replacing lines 4 to 17 on page 1 with the following. 1. Section 515 of the Act is amended by adding the following after subsection 3. 3.1. Before making an order under subsection 2 in respect of an accused who is charged with an offense in the commission of which violence was used, threatened, or attempted against the accused inmate's partner, the accused's intimate partner, the justice must ask the prosecutor whether the intimate partner of the accused has been consulted about their safety and security needs. 2. Subsection 515.4 of the Act is amended by adding the following after paragraph E. E.1. Where an electronic monitoring device, if the Attorney General makes the request. 2.1. Section 515.4.2 of the Act is amended by adding or at the end of paragraph A1 and by repealing paragraph A.2. 3. Paragraph 515.6b.1 of the Act is replaced by and B by replacing line 1 and page 2. Sorry, let me repeat again. B by replacing line 1 on page 2 with the following. 4. The Act is amended by adding the following. Motion number 2. Ms. Ferreri, seconded by Ms. Gray, moves that Bill C-S-205 in Clause 2 be amended. A, by replacing lines 9 to 12 on page 2 with the following. 810.03. 1. A person who fears on reasonable grounds that their intimate partner will commit an offense that will cause personal injury to them, to their child, or to a child of that intimate partner may lay an information. B, by replacing lines 32 and 33 on page 2 with the following. 5. An order, either subsection 3 or 4, must be made in a timely manner. 6. The provincial court may commit the DEFEN trait d'union. C, by replacing line 1 on page 3 with the following. 7. The provincial court judge may add any reasonable. D, by replacing lines 4 and 5 on page 3 with the following. Or to secure the safety and security of the informant, their child, or a child of the defendant, including CONDI-. E, by replacing line 20 on page 3 with the following. RECTLY, rectly, comma, with the informant, a child of the informant, or. F, by replacing lines 1 to 5 on page 4 with the following. 8. The informant may provide submissions in writing on the conditions that the judge may add to the recognizance under subsection 7. 9. The provincial court shall consider whether it is desirable in the interest of the informant's safety, or. G, by replacing